Well, hello everyone, and welcome once again to Uncivil Law. For today's story, we have an academic article from the University of New South Wales in Australia, a law review that is soon to be published in Georgetown. And this is critical of lawfluencers, which is a term I've apparently just heard now just for the first time. So someone wrote a critique of lawfluencers, and they wrote it up in an academic article. That's fun. And so we're going to read this thing and respond to it because, hey, if they can write an article, we can respond to the article. Freedom of speech is good for everyone. They're certainly entitled to their opinion, no matter how stupid it might be. And I'm entitled to response, no matter how stupid I might be. That's fine. We can all participate together. It's great. So we're going to respond to this academic article that is to be published in Georgetown. You can see this is from the University of New South Wales Law and Justice Research Series, and this article is entitled Lawfluencers, Legal Professionalism on TikTok and YouTube by Anthony Song and Justine Rogers, who are pictured in the thumbnail that I have created for this. That's fun. They apparently are both professors. As we can see here, there's a description of them. One of them is a research fellow, faculty, and one of them is an associate professor. So so they're both professors of varying descriptions. So we'll skip the abstract and we'll go right to the heart of the thing. All right. Introduction. A man wearing a glittering green tuxedo and purple and yellow floral tie dances to the camera, lip-syncing a Taylor Swift song, raising his hands to the camera to show off chunky diamond rings. He twirls, steps back, and then waves goodbye to the viewer. At 12 seconds long, this video was posted by U.S. lawyer Kevin Kennedy on his TikTok page at Kennedy Law Firm. On the poster are the hashtags Kevin's Got You Covered, Lawyer, Dance, Bejeweled, Shimmer, Glitter, Taylor Swift, FYP, For You. This video attracted 30,900 likes and 491 comments on TikTok, the social media platform that allows users to create and share short form 15-second to 10-minute videos. Apparently, the people at USNW are not a fan of the mantra "dance like no one is watching." I guess that yeah. Kennedy is known for resembling the slick fictional lawyer Saul Goodman of American crime drama Better Call Saul, a persona that Kennedy has embraced as part of his self-presentation online, which incidentally sounds like a pretty cool idea. I kind of wish I had had it first, to be honest. In this video just described by singing the Taylor Swift song, Kennedy is referencing a then recent event when Ticketmaster's website crashed due to overwhelming demand for Swift concert tickets. Fans vented their frustration on social media and joined lawsuits against the ticket company. Okay. Elsewhere across the cyberspace, Leah Miller, a legal content creator, begins a live stream, video occurring in real time, like this one, on her YouTube channel, Leah Live, titled Lawyer Reacts to Taylor Swift, Ticketmaster Drama. Miller provides her legal opinion on the case and responds directly to live comments and questions from viewers. I mean, yes, that's kind of what the legal analysts do here. It's kind of what the legal analysts and legal educators do. We see a story in the news that's happened, and we try to provide a reasonable legal analysis of potential legal issues that are obviously present in such situations, hopefully with some tension to both potential avenues of attack and avenues of defense. And because people might want to know things, and it's interesting, and it helps to educate people, helps to demystify the law. It's a good thing. Cool. Miller does not provide any verbal or written disclaimers in the video about whether she's saying amounts to legal advice. The only disclaimer appears at the very bottom of the video description, which to see requires the video to click the button Show More. Above the disclaimers are affiliate links, web links that earn commissions to various products, including makeup, filming equipment, and hair products. Miller's video is one of many among YouTube in which lawyers share their reactions to event. Not for nothing, by the way, but I also note that your paper does not apparently include a prominent disclaimer that this is not legal advice. I can't help noticing that you're directly addressing a particular person Leah Miller. You are directly addressing something that she particularly did, and you're noting that she did something and didn't do something. And I mean, what you're saying could be interpreted as suggesting that what she did was inappropriate or unethical in some way. You wouldn't be providing legal advice in any way, would you? And you wouldn't be doing so not disclaiming that you're not providing legal advice. I mean, someone could interpret what you're saying. I mean, obviously you're discussing a particular situation in the exact same way Leah Miller was discussing the Taylor Swift situation and analyzing that. You seem to be analyzing her video itself and suggesting that perhaps not all is right. You wouldn't be providing her legal advice without a disclaimer, would you? Okay. These are depictions of lawfluencers or lawyer influencers, which is a term I've literally never heard before now. And they have a citation. And then they say other related popular terminologies to specific platforms include Law Talk or Lawtube. Neat. I've never heard lawfluencer before, so maybe I'll adopt that for your own. Uncivil Law, your friendly neighborhood lawfluencer. What do we think if I rebrand myself? Uncivil Law, your friendly neighborhood lawfluencer. Is that a good thing or a bad thing? Well, I'll get back to you on that one. These are depictions of lawfluencers or lawyer influencers. Lawyers using their legal knowledge and identity, both personal and professional, for the production and sharing of video content. And the word content is in quote marks for some reason. Why is the word content in quote marks? Video content. Why is the word content in scare quotes? Is it not content? What the hell? Online. An influencer's aim is to accumulate a following to then influence. These quote marks are confusing me. Why are these in quote marks? An influencer's aim is to accumulate a following to then influence its behavior. Who's it? The following? Primarily as potential consumers and otherwise monetize. These quote marks are making me laugh. Otherwise monetize their social media presence for commercial gain or cultural capital. Oh, these are citations. That's why. Apparently, these are all from self-branding, micro-celebrity, and the social media influencers. So you're quoting these because they're terms you found in some law review article somewhere? Wow. Neat. Okay, fine. I mean, sure. I guess. Today, lawyers across practices of all sizes are sharing legal information, analysis, and advice, and or providing entertainment to global audience, sometimes in the millions. How very dare we? How very dare we? Wow. I mean, how very dare we? As a result, there are constructing public personas and brands, carving out so-called niches as sources of legal authority and entertainment. I guess, yes. Attracting new clients and building communities, and in many instances making considerable amount of money. Oh my God. Oh my God. The lawyers are providing commentary to people and people enjoy it. And maybe they learn something along the way, and sometimes the lawyers get paid for it. Wow. Yeah, okay. Yeah. That's good. Yeah. This activity is new territory for law, which has long had an aversion and prohibition on advertising of any kind. And I take note here, they apparently in footnote 10 cite for this proposition that advertising is bad. They cite James Reed, Advertising in the Legal Profession, 28 Dicta 101, 1951. Okay. I don't know whether or not, publications flow slower to USNW in Australia. I don't know if you're behind the curve or something, but advertising has been legal for lawyers since 1971, when the U.S. Supreme Court said the bar couldn't stop us. So Your citation's a little out of date there. That's okay. It's only been legal to advertise for lawyers for the past 50 plus years. But maybe you haven't figured that out yet in Australia. Yeah. At least in the US. I can't speak to the laws of Australia. Maybe you guys are just jealous down there. I don't know. Yeah. But it's been legal since 1971. So you might want to update your law books on that one. Traditionally, and if we mean traditionally, we mean like prior to 50 years ago, I guess, lawyers gained work through word-of-mouth referrals and on larger institutional scale through symbols, self-regulatory authority, and monopoly protection supporting their professional status. However, as the two opening examples illustrate and detail in this article, much has changed in recent decades, and there are now clear-cut regulatory, business, and technological affordances on this move to lawyers using and making money out of video-based social media platforms. There are also distinct social, economic, political, and again, technological forces shaping how this activity is rolling out. You are correct. Amazingly enough. You know, as technology has changed, lawyers have also changed with the technology. I know, it's amazing. We no longer necessarily communicate only by written courier, written with our finest feather nibbed pen, and, you know, on parchment that was lovingly handmade by a master crafter. You know, sometimes we use new technology as part of our craft and communication methods. I know, it's amazing. Our article consists of meanings of this new type of endeavor in legal practice, focusing on the currently leading video social media platforms YouTube and TikTok. Lawyers' use of social media has attracted scholarly attention. However, outside a few professional pieces, comparatively little is known about law fluencing and the particular working of video platforms in the legal context. Video social media is different from text-based or image-based social media because of its real-time audiovisual format. That makes no sense. I need you to justify that. I need you to justify. You can't just say that. You say video social media is different from text-based or image-based social media because of its real-time audiovisual format. Different how? Other than the obvious technological difference, different how? Different in what way? Is it different bad? Is it different good? How is it different? In what way is it different? Why does it matter? I mean, you wrote a law review. I'm writing as we speak. I'm literally writing into existence by my speech. I'm writing a video essay. Why is it different? Why is it different? Because yours got citations? I mean, I could get citations. Actually, incidentally, I already have one citation in mine. I already have a citation. I cited the U.S. Supreme Court case from 1971, so I've got a citation. You know, I can do more citations. If you like more citations, I could do more citations. Different how? Different in what way? Is it different bad? Is different bad? Okay. Video social media is different from text-based or image-based social media because of its real-time audiovisual format. Do they mean, well, they just say video social media. And then they say real-time audiovisual, which isn't necessarily true depending on how you understand real time. If it's an edited video as opposed to a live stream, then it's arguably not real time, but it would still be video social media, right? If I did edited video, is that real time? I don't know that's real time, but okay. Are you just talking about live streaming? And if you're just talking about live streaming, you could have been clearer there. By design, this technology is interactive. Again, not necessarily. And highly appealing. U.S. lawfluencer Michael Mandel, Law by Mike, holla, for instance, attracted 3.5 million followers on TikTok within 7 weeks. Moreover, as a form of knowledge influencing, again, these quote marks are kind of throwing me off. Holy shit. Moreover, as a form of knowledge influencing in which the influencer is sharing expertise more than lifestyle to build a brand, lawfluencing is intriguing. Traditionally, successful influencers strategically portray themselves as having a relatable identity as an amateur or non-expert. I don't know that's necessarily true. There are a lot of professionals in a lot of fields who make videos and somewhat successfully in some situations. There are doctors with popular videos, and there are lawyers, and there's other professionals. So I don't think being a professional is a barrier to commentary on YouTube or anywhere else. That doesn't sound right to me. But influencers today, especially knowledge influencers, I'm a knowledge influencer. I'm not sure 100% what that means, and I'm not sure I like it. I'm a knowledge influencer. So I'm trying to increase your knowledge. Am I influencing you to have more knowledge? Is that bad? I'm not sure. When you say knowledge influencer, it almost sounds like you said, it almost, to my ear, when you say knowledge influencer, it makes it sound like I'm peddling knowledge, like some sort of snake oil salesman. I'm out there with my street cart on some street somewhere, buy 5, get 1 free knowledge, and with some shady business practices in a fly-by-night operation. It sounds all so shady. Man. I'm a knowledge influencer. I guess that's bad somehow. Must choose which balance between amateur, trusted peer of the people, and professional, trusted expert with certain duties and values, best suits their brand and audience. Well, I suppose that's true, but I don't understand what that means. And I suppose that would be true of anyone. You might have different aspects to yourself, or different interests, or different hobbies, or different knowledge bases, and what your channel is about may not necessarily reflect the totality of you, because it might only be part of you. Because, maybe you are a kayaking channel, I don't know. And, but kayaking probably isn't everything there is about you. And law probably isn't everything there is about me. Although it's closer, probably, lol. But yes, sure, you have to figure out what your brand is going to be and communicate accordingly, I guess. So sure. Our article examines the nature of lawfluencing and its implications for professionalism. The word professionalism is in quote marks. Okay, guys, we're not talking about professionalism. We're talking about professionalism. Or for types of identities, expertise, relationship values, and institutional arrangements that have typically marked out professional status. Could we see the advent of legal video marketing, for example, as a welcome adaptation of professional, traditional public service and access to justice commitments? Could we also see the way in which lawyers can themselves reclaim work autonomy, well-being, and satisfaction against workplace pressures and controls? Or is lawfluencing simply another way in which the law and law identity, at the behest of giant technology corporations, holy shit. In what way does lawfluencing pose significant and novel risks to law's basis for trust and legitimacy? In answering these questions, this article contributes then to the ongoing wider discussion about the challenging nature of law and legal practice. You are more than welcome to write your article, and I will balk you accordingly, and then I assume you will balk me, and that's part of speech. That's how speech works. But yes, it's true. I suppose we are out there communicating to people about law or medicine or whatever your interest / hobby / profession might be. Wow, I know. People are using the YouTube to talk about themselves and the things they like. I guess Australia just found out that Lawtube, that YouTube exists or something. Maybe they just got it rolled out down there. I don't know. Maybe YouTube is new to them. Our article is structured as follows. Part 2 explains what lawfluencing or legal marketing is within the wider confluence of influencing. It describes types of videos lawyers are sharing and creating, and what blends a professional versus amateur, and what levels of success. It also pinpoints the main drivers behind the uptake in law. Okay. In the process, Part 2 also clarifies some of the technological features of the video social media platforms that explain how they work and why they present certain opportunities and risks for lawyers and the public. Part 3 considers the implications of lawyers' use of social media video platforms on professional values and identity, relationships to the client and public, and the status of legal professionals and legal system more broadly. Part 5 concludes and suggests avenues for further research. Exciting. Part 2. In this part, we define we define lawfluencing, describe the sort of content, again, the word content is in quote marks for some reason, and the forces that are both enabling these activities as well as heavily shaping what they look like. Increasingly, influencing via video platforms is being pursued by individual lawyers in their professional role for self-branding, self-promotion, creative purposes, and on behalf of their firms. It is true. Lawyers do it for the sense of creating things. They do it for the sense of branding. They do it for the sense of promoting their law firms or themselves. Wow. Deep. Amazing. Influencing is the activity of sharing lifestyles or knowledge on digital channels to accumulate a large following, again in quote marks for some reason, or network over which one has influence or persuasive power. Influencing is a branch of digital marketing, which is broadly the use of online technologies to acquire customers, build customer preferences, promote brands, retain customers, and increase sales. Also, by the way, I notice now that they do not use the Oxford comma in their paper, and they are the devil. So I already didn't particularly like these guys, just generally speaking. And now they're not using the Oxford comma, and they are Satan. But influencing also has elements of sociality, community, and performance that makes a difference to other forms of marketing. Moreover, to be a successful influencer requires mastery over certain technological and self-presentation skills. Okay. Before the advent of social media and the language of influencing, influencers, who were then known as opinion leaders or media personalities, were kind of an elite, those with access and skills to interpret mass media, command attention, and then pass their understanding and opinions on to the public. Celebrities, mostly TV and film, were a branch of this group, selling products and services through a mystique and a lure. Today, the accessibility of social media means that in theory, anyone can become an influencer. Oh my God, we've democratized media, people. We've democratized it. Because now anyone can post anything. There are no more gatekeepers, man. Anyone can get on the internet and they can say anything. Anyone actually has the ability to actually say anything they want at any time about anything. Oh my God. Certain influencers are marked out from traditional opinion and even celebrities because they also share details of their daily personal life, making them more accessible, relatable, believable, and intimate. Sure. Yeah, some of us talk about things going on in our lives too. That's true. However, social media also adds a third stakeholder to the classic influencer audience model, the platform. Well, I don't know about that, incidentally. I'm not sure the degree to which that's kind of always been true to some degree, right? If you are not literally using your own platform, then the platform has always been to some degree a thing in the middle, right? If you were communicating through a newspaper, that's a platform. If you're communicating through a TV station, that's a platform, right? You don't own the TV station. You don't own the newspaper. in most cases. So the platform has always been, for the most part, somewhere in this equation. So I'm not sure that's necessarily a new problem, but okay. The platform's algorithms adapt to audience preferences in a process known as personalization, which in turn shape and usually ultimately dictate the actions of influencers. Well, in so much as I try to find content that will be more well received, then yes, I'm trying to find content, because I could talk about basically an infinite number of things when it comes to law. Law is an incredibly deep topic, as I'm sure you could appreciate. And like many things, as you look closer and closer, the details get greater and greater, and basically becomes an infinite. It's like a fractal, right? The closer you look at the fractal, the more it just spurns off and becomes even more detailed and intricate. So yeah, you could talk about just about anything. You could basically talk about nothing but one subject. You could talk about nothing but one thing, or you could be broader or whatever. And it's up to the creator. And for myself, I try to pick content that I think will be interesting and informative, and hopefully will gain a wide audience, because I'd like people to see it. I like to be successful in my craft. That is true. You have caught me. I would like to be successful. Yeah. As we detailed shortly in part 2C, and by the way, this problem, of course, as I mentioned, or at least alluded to, is not new when it comes to social media, right? If you were communicating via a TV station, or you're communicating via a newspaper, or communicating via a magazine, or communicating via some other mass distribution platform, then the popularity of the content is going to be a major driving factor for the platform as they choose what to publish themselves. The newspaper chooses what articles to run. The TV station chooses which stories to cover. The magazine chooses which articles to print, and so forth and so on. So yes, I mean, everyone throughout basically all of publication history has been trying to, gain eyeballs and attract people to consume the content. So yes, this is, again, not a new problem. Meanwhile, the term micro-celebrity has emerged to describe the practices influencers use on social media to successfully build their personal brand and sometimes establish fame, but on a small scale or in a specific domain. Sure, micro-celebrities self-present as public persona to be consumed by others, use strategic intimacy to appeal to followers, and regard their audience as fans. Yes, I guess. Branding is about creating symbols for a commodity, which ostensibly simplifies the creator's decision-making. Well, I don't know if it simplifies it. I don't know about that, but I do try to, this is the Uncivil Law channel, which is a bit of a brand, and try to present content consistent with that, I guess. All right. By sharing their videos on popular apps such as TikTok or YouTube, influencers are hoping to construct and project themselves as a brand. I guess by necessity, sure. They seek to entice the public. Ooh, again, that entice has a certain spice to it. The word entice. Again, entice has that sort of nefarious, trying to entice you, trying to trick you. Has a little edge to it. They seek to entice the public as potential consumers to engage with videos and usually also buy their products and or services. Influencers primarily generate revenue through engagement from platform payouts once a certain number of viewing hours are met, and from dependent on viewers, advertisements embedded in videos, and affiliate links. The performance of micro-celebrity was initially centered on lifestyle topics and within consumer industries such as travel, beauty, and fashion. However, knowledge influencers, again, there's those quote marks, knowledge influencers now engage in these practices to curate their image in certain ways, as opposed to like everyone else, as opposed to like literally everyone else. Are you telling me that literally everyone doesn't try to present themselves in a certain way and, you know, curtail their image? And everyone's trying to present themselves in a certain way to others. I mean, you know, whether that's authenticity or not, right? So even in trying to be my true self, that's still a decision on how I'm presenting myself. That's still an image. You know, it's still a thing. Even if I'm trying to be as authentic as possible and real as possible and, you know, raw as possible, that's still a brand decision. That's still an image decision. That's still a, you know, a decision that reflects who I want to be. So even authenticity and everyone does that to some degree. You know, if your image is that you're aloof and don't care, that's still an image. I don't understand. Knowledge influencers share technical information and expertise to lay audiences, often interwoven with personal posts or humorous anecdotes about professional life. As signaled in the introduction, these influencers build their brand then on both elite, erudite knowledge. Erudite is a nice word. Again, it's a very elite erudite. It makes us seem pompous and arrogant. We're both elite and erudite. We're pompous. We're arrogant. We're aloof and elitist. We are your betters. And relatability, amateurism. Indeed, to capture this contrived aspect, Maddox, really? Wow. Okay, Maddox makes an appearance. Maddox has proposed the term calibrated expertise to describe the performance strategy in which professional experts harness social media affordances, platform dynamics, and aspects of micro-celebrity to impart information. These knowledge influencers now span the field of medicine, dentistry, finance, as well, and as we illuminate law. I'm sure they don't intend it, but illuminate law, Illuminati confirmed. I'm not sure about the word choice illuminate there, but okay. Whatever they are selling, a product or professional service or both, influencers selling an identity that is singularly charismatic and responsive to the needs and interests of the target audience, which I would argue, incidentally, once again, is true of basically all media throughout all of time. This is not an influencer problem. This is a media problem. You could just say media throughout all of history is selling identity that is singularly charismatic and responsive to the needs and interests of the audience. Yeah, I mean, you know, yeah. To give some perspective to this discussion in the legal and professional context, traditionally, the legal professional's influence was over barriers to entry, gender, race, social background, qualifications, knowledge and expertise, and government audiences, which granted it an effective monopoly on courts, legal work, and profession's own rules and regulations. At least in England and Wales, the common law countries, status or influence was achieved through a combination of such controls, built on professional historical achievement to elite institutions, including the Crown, certain prestigious schools and later universities. Thank you, Tony P, for the gift memberships. They're appreciated, as you help validate this article by helping to support the channel so it can continue to grow. I appreciate it. In this configuration, legal knowledge and the entire legal system, including its culture, practices, and identities of its members, were, for the most part, shrouded in mystique. This exclusivity has, to the extent it still forms, it still exists, functional roles, including in the maintenance of the law's objectivity and predictability. This means of influence also secured lawyers' financial and status rewards, and in consideration, lawyers were required to commit to public-minded ethical behavior, which implies that we're not doing that now, by the way. Which implies that we're not doing that now, even though I would take note that the nature of this particular media makes it more public-facing than arguably other forms of media, because now everyone can contribute and now all the lawyers can contribute. So if lawyers are in fact required to commit to public-minded behavior, then social media is making that a lot more possible, because now the lawyers can actually go and talk about law and inform about law and educate about law and demystify law and help people understand this field a little bit better. And it's also good for me because I get to talk about something I like. So that's nice. Okay. Excuse me 1 second. I have to pick up something at the store. Give me 1 second, please. Groceries achieved. Let's see, where were we in this article? All right. Let's see, where were we? Okay. With an effective monopoly from the state, lawyers were prohibited from advertising or touting for their work, a practice that they ought not to have felt the need to engage in. Yeah, that's only not been true for the last 50 years, but that's okay. It's only not been true for the last 50 years. Again, the Supreme Court of the United States found the First Amendment. And they're like, lawyers can actually, speak too. It's cool. This prohibition and other related customs and rules of etiquette were formalized in statutes and regulation. To engage in advertising or marketing would mean that lawyers could not turn to their fiduciary obligations, and lawyers in competition with each other would undermine the collegial spirit and altruism of the profession. Wow, this is old school. Finally, and at the interpersonal level, lawyers historically had and have influence over their clients. Well, yes, necessarily. That's kind of the idea, a little bit. Especially more vulnerable individual clients. However, for most of the profession's history, this relationship was not the critical level of professionalism, collective authority. In contrast, the key level of power in law fluencing is between the individual lawyer and a group of anonymous people in which the lawyer is trying to transform into a loyal community. Yes, ideally, I would like your loyalty. That would be nice. Hopefully, I give you something to earn that. And groups of anonymous people which lawyers trying to transform, and possible consumers, clients of their legal services and other products. But in this instance, when the lawyer's activities are turned by shape by that group's needs and appetites as consumers of social media broadly. Well, yes, once again, I'm going to try to make content that will appeal to, more people. So more people will watch it and more people will get legal education and more people will enjoy it. and improve my craft and all those good things. I would like this channel to grow continuously. I am not content with my 142,000 subscribers. I'd like 1 million subscribers. I'd like 5 million subscribers, please. I'd like to be the best I can be in my craft. That'd be great. While lawyers have always had to shift their work offerings to adapt to their clients' projects and take advantage of business opportunities, again, yes. I mean, lawyers traditionally trying to get the most clients through the door, right? So lawyers have to figure out how to get the clients and, to try to adapt themselves so more clients will choose them. So again, not necessarily a new problem. This type of influence is very different to traditional professional influence in how the image or the brand of the profession has been projected, accessed, and construed. Only in so much as you're alluding to a stuffier time. Yes, David, they are absolutely trying to ship the term lawfluencing. I'm thinking about adopting it, though. I don't know if anyone has ever done it. Welcome to Uncivil Law, a lawfluencing channel for the masses. Could be good. I'll work on it. I'll work on the branding. Could be good. The main types of videos that lawyers have been making to self-represent, promote, and market themselves are legal education, law explainers, news. Why do they feel the need? Oh, that's a quote again. They have to have a quote. They can't just say legal education. They need to say law explainers because someone else in some other article one time used the term law explainers, and God forbid they have a thought of their own and they have to have a quote marks, ma'am. News and legal commentary and video blogs, also known as vlogs. Each of these genres has been created by the platforms and related cultural trends, bringing their own style and vernacular. In all of these, the law influencers may be offering legal advice. No, we try very much to avoid that. We try to provide good quality legal commentary and decidedly do not want to try to provide individual legal advice. But when people ask us questions, we try to give them the broadest strokes possible because we want to be helpful. We don't want to be mystifying. So if someone asks a question, I try to answer it as broadly as possible. Also, depending on the question they asked, which may or may not give them the answer they're looking for, but yeah. To reiterate, lawyers are typically not making these types of videos as one-way advertising, which legal video marketing might intend to, but rather as two-way interactions to build loyalty and engage audience or community. This is relevant for two reasons. First, indicate again that videos and influencers are in many ways co-constructed based on the viewer's desire. Yes, I mean, that's, I suppose, true. I'm trying to find an audience. And so I'm trying to be responsive to my audience. That's fair. It's one of the reasons why, for example, recently I shifted into more edited videos and scripted videos with an actual editor and seeing if you guys will like that better. And doing fewer live streams because I'm trying different things and seeing what will work. Wow. You know? Second, once the lawyers community is of a certain size, they can monetize their videos and thus earn money regardless of whether the viewers themselves ever pay for legal services. Yeah, I know, it's great. You guys get all this stuff essentially for free sometimes or close to it. You know, if I charged each of you for an hour of my time, yeah. As a final note, while all these genres are largely shaped by the platform and its culture, and therefore have all the elements of performed authenticity and faddishness, they illustrate the spectrum from professionalism on one end to amateurism on the other, upon which the influencer must decide the position of themselves. Law explainers, as the first type, are videos that explain legal terminology, ideas, or process in a clear, accessible way. For example, on YouTube, the Shrews Law Group, a California firm, uploads 1 or 2 videos per week, usually 2 to 5 minutes long, with topics ranging from recovery and hit and run, use of California's medical marijuana cards interstate, and the legal outcomes of underage drinking. Meanwhile, U.S. husband and wife lawyers Mel McLean and Ashley Stanley provide bite-sized explanation of legal jargon on TikTok at The Law Says What. Cute, good name. I like that. And also larger educational videos on YouTube. Having originally started their TikTok in 2021 to promote their book, they now have about 1 million followers. While the Stanley's topics are generalists, other lawyers specialize their followings by focusing on their practice areas. For example, U.S. lawyer Limor Moajizis at Lawyer Limor has built an audience of some 500,000 by creating videos on family and divorce law, with her biography describing herself as an attorney analysis and commentary on celeb legal news. And then they wrote sick because apparently they didn't like the exact way that she wrote it. Because sick just means this is repeated verbatim. This is provided verbatim. And so they're like, oh, this is a mistake, I guess. They don't like the way she wrote it. So we got to write sick to highlight our disgust. In addition to direct transmission teaching, another common approach to Law Explainer is for the creator lawyer to share a clip of a real-life legal offense, poll the audience on who they think is liable, and then reveal the answer in a separate video with legal commentary. This type of video is likely more engaging and interactive for the audience, but also closer to giving legal advice than merely explaining it. No, it would not be, because we're analyzing the clip and then providing our best judgment about what it means. It's not legal advice, and certainly not legal advice to the audience, because it's not their situation. All right, you're watching a video clip of some offense somewhere, and then you're like, okay, what do you think about this audience? And the audience provides their answer. You're like, okay, here's my answer. This person is liable. That's legal advice to whom? Unless you're the person depicted in the video, no. And even then, no. One of the most successful lawfluencers, U.S. lawyer Erica Kohlberg at Erica Kohlberg, uses this specific approach to content creation. Her signature videos offer viewers advice on how to read and execute the fine print of certain contracts, from American Airlines to Nike. This typically involves Kohlberger acting out all the roles in a scenario. For example, a consumer exercising their consumer rights against a store representative. I know her videos. Yeah, I know her. I know her from her shorts. Yeah, she's fun. She's fun. I know her from her shorts. At the time of writing, Kohlberg has amassed 9.2 million TikTok followers, and her videos have attracted a combined 66.9 million views. She has over 19 million views across all her platforms. These are all professional videos, but with different degrees of calibration to make them more accessible and appealing. Meanwhile, it's now common for people to access their news via social media. Lawfluencers have responded by providing news-driven video content, commentary not only on legal trials, but also legal aspects of pop culture, social, and political topics. Yes, amazingly enough, the lawyers that are commenting are analyzing things through a legal lens. I know, it's truly amazing. The lawyers who are commenting are looking at things and commenting on them through a legal lens. You have caught us once again. It's amazing. It's amazing. American lawyer and content creator Celia Z advises lawyers to take advantage of popular trials, particularly involving celebrities, to give your own take on the proceedings and establish yourself as an authority. A striking illustration is Depp v. Heard. Yeah, you had to wonder when it was gonna show up, baby. You had to wonder when it was gonna show up, baby. Oh yeah. Depp v. Heard. Depp v. Heard. Let's play that song again, baby. Play it again, Sam. Woo! Depp v. Heard time. Yeah. A striking illustration is Depp v. Heard, in which actor Depp sued his wife Heard for $50 million over a 2018 op-ed she wrote alleging that he had abused her. The trial was broadcast live from Court East Day, accelerating a booming trend of amateur and professional legal analysis, amassing huge social media audiences. Among the lawyers discussing the case, or dissecting the case, was Emily Baker, former deputy district attorney for Los Angeles, whose YouTube page now has some 700,000 followers. I believe that number's a little higher now. Baker live streamed hours of analysis every day, including 5-hour live streams from closing arguments, which alone attracted 2.3 million views. A journalist described this phenomena of live stream video a bit like court TV, but with unvarnished analysis and a flood of quippy user comments coming in via Super Chat, a YouTube tipping feature that allows users to have their comment highlighted on a live stream in exchange for the tip or payment. Yes, but, you know, in a lot of ways, this is more reminiscent in some ways of really like, this is in some ways what's going on is more reminiscent of how courts and trials were covered in the pre-mass media age. So if you go further back in history, you know, before the advent of like newspapers and stuff, or at least before the advent of literacy, which, you know, even after newspapers were invented, took a while. So if you go back, you know, before the advent of literacy, you know, into Europe, and you go and you look at people would often go to court because it was the thing to do, because, well, it's an activity, it's entertainment, and it's happening and it's free. And so the hoopla over trials and the public discourse and the public people exchanging their thoughts and opinions and their interactions with each other is in some sense ancient, because it was the only thing to do. And so people talking and commenting about the trial, it's like, yeah. And now the only difference is that, I mean, everyone can really see and hear everyone at the same time, because, you know, that everyone can see each other's chats in real time, as opposed to just have whoever you happen to be next to at the time. But the flood of the average user's comments is in some sense old, but not new, you know? So yeah. The crier, you know, the crier hanging outside the courthouse, you know, shouting the updates and so forth and so on. You should see the crowds public executions used to draw. Yeah, man, that's a good point. Psychological projectionist, that's a good point. Yeah, back when executions were fun for the whole family. Yeah, everyone would show up. It was basically half carnival. There was whatever the 18th century equivalent of funnel cakes and cotton candy was. Bring the children, fun for the whole family. You better believe it, baby. You know it. You know it. Meanwhile, on TikTok, the Stanleys, the lawyer duo mentioned above, made, for example, 1-minute video explaining a distinct pop culture aspect of the Depp case. Why Heard's reference to the British model, Kate Moss, in her testimony was likely a backfire, which attracted over 13 million views. As another journalist observed, legal commentators say they're having fun and making a tidy profit. We did have fun. Some of us made a tidy profit. Not all of us. Some of us did better than others, but it's okay. This monetization element raises novel issues for legal professionals, which we considered in part 3. Boy, oh boy, I wouldn't know what to do without these people. I'm so glad these people wrote this article, because God knows I wouldn't know what to do when it relates to legal professionalism, but for these people giving me their grace. This is great. I'm so glad these people are here to tell me. Moreover, lawyers are also creating entertaining videos or online diaries called vlogs. I'm not sure anyone calls them vlogs anymore, incidentally. I couldn't say for sure, but I don't think the term vlog is exactly well used these days. Social media users typically come online for fun, to vent, to escape, to find a sense of belonging, or to simply fill time. The top lawyer creators are entering to those needs, joining other professionals engaging in similar activity. Lawyers are providing a day in the life of a lawyer or behind the scenes videos of working in legal practice. These videos offer, or have been described as offering, more realistic or authentic pictures of law than that found in TV shows and movies. Well, there's that for sure. American lawyer Devin James Stone, and which we're going to use his full legal name for some reason. I didn't know his middle name was James. Why do we need to know that? American lawyer Devin James Stone, known for his YouTube channel Legal Eagle, has a playlist of videos of himself titled Real Lawyer Reacts, which describes a real lawyer reacting to famous courtroom dramas like Law and Order, Suits, The Good Wife, A Few Good Men, and My Cousin Vinny. Learn what's realistic and what's pure Hollywood as he breaks down legal movies and TV shows. Other law influencers are creating entertaining videos purely for engagement purposes, to increase their online purposes and attract followers. For example, filming themselves lip syncing or dancing. Okay. On the professional amateur spectrum, these videos sit furthest towards the amateur or trusted peer event. Okay. I don't know if the lip syncing works without the music in the background, but, you know, I did my best. That was I Want to Dance with Somebody, in case anyone wants to figure out what that was. Finally, lawyers are also using their videos and audiences they create to sell products. We have already mentioned law videos alone can generate income for law influencers. Selling their own to others, it is another option. In other words, law influencing is not just about leading viewers to consume their legal services, but also buy, for example, books or merch. For example, Legal Bites. Holla, Legal Bites got a shout out. Nice. For example, Legal Bites, a YouTube channel by U.S. lawyer Alita Mazika, has merchandise shop selling branded clothes, accessories, and drinkware. Holla, Alita. I love you. Other law influencers that build a community. These videos can indeed be embedded within videos, also more one-way or more explicitly advertisements. Rudy Giuliani, perhaps best known for being Donald Trump's lawyer, often live streamed or posted on social media while acting in a significant political role. And these Giuliani-directed advertisement products included gold coins, supplements, cigars, and protection from cyber thieves. It is common for law influencers to mix, match, and combine these different kinds of content. For example, Legal Eagle, in addition to explaining courtroom drama, also explains news and sells his own product called Legal Eagle Prep, an online course designed for law students to crush law school. Again with the sick. Again with the sick, because we don't like it that way. Chat demands merch. We do have a merch store. You should check it out. As suggested in Part 2A, law influencing and its associated advertising deviates significantly from professionals' aristocratic ethos. That gentlemen did not spurk their wares. Okay, so I guess these people want us to go to a more aristocratic, elitist, reserved style. Okay, that's nice. Why did I skip the abstract? Because the abstract by its nature describes the content of the article. That's why. The abstract is supposed to be a summary of the article. Why read the abstract when I can read the entire thing? I'm reading the entire thing, so why read the abstract? It seems repetitive. It's the same reason, incidentally, that if I were going to read a full U.S. Supreme Court, I wouldn't read the syllabus. Because why? Because why read the summary of the thing when I'm reading the thing, right? So if I'm just reading the syllabus, then I'll read the syllabus, then I'll just read the syllabus. But if I'm going to read the entire thing, why read the syllabus? Because it's just a summary of the thing. Why not read the thing? It seems redundant. As suggested in Part 2A, law influencing and its associated advertising deviates significantly from the profession's aristocratic ethos that gentlemen did not spurk their wares, and traditional prohibitions on lawyers' advertising generally, which again has not been the law in the United States since 1971. Please bite me. If we treat practitioners at this time as representing the profession and therefore a part of the brand, then this was certainly a type of a lawyer for a long time male. What the fuck? Who dressed, spoke, and interacted in certain ways associated with the upper class and acquired clients by word-of-mouth referrals. Are you advocating for return to that or not? I'm so confused right now. It's like, I don't know. Of course, several demographic, social, and regulatory changes in the profession, particularly dramatic over the course of the second half of the 20th century, have meant that the profession has now branded itself and can be branded in complex, multifaceted, and more and less distinct and deliberate ways. Yeah, the university gift shop doesn't count as spurking your wares. Also, do these people by any chance have a book or a law book or a textbook by any chance that they've contributed to or recommend in particular, just out of curiosity? First, a key enabler has been the broad marketization of the profession, in which many of the profession's restricted practices have been dismantled, replaced by new discourse, rules, and regulations supporting competition and consumerism. These moves have been largely driven by the government and large commercial firms. For common law countries, at least, there is no longer any express prohibition on advertising, so long as it's not false, misleading, or offensive. Well, he finally got around to it, mentioning it. We're on page, what are we on page of? 14. It took you to page 14 to mention, oh, by the way, this is no longer illegal. That's great. That's great. Good work there. And then you cite for that proposition something from the Australian something. And then you cite American model rules. But you don't, but interestingly, you don't cite here the U.S. Supreme Court case from 1971, which would be a much more interesting citation. I think it's Arizona, State Bar of Arizona versus. You don't cite for some reason. So, yeah. A second critical driver is technology. The internet revolution has offered and created new ways to form communities, interact socially, spend time, and do business. Both software and hardware have advanced monumentally. Across these devices, the typical internet user now spends 7 hours per day on the internet, 35% of which is on social media. In turn, the way we consume information and make purchasing decisions has changed. Platforms allow anyone to broadcast the self, increasingly now in video format. For so-called content creators, what the fuck? What do you mean so-called? What do you mean so-called content creators? What do you mean? I am in fact creating content. Blow me. For so-called content creators, the ubiquity of high-resolution cameras, cheap mobile internet, and easy-use production tools has dramatically lowered the barriers for entry for video content. Every minute, 500 hours of content is uploaded to YouTube, compared to 48 hours in 2013. And over 167 million videos are played on TikTok. Indeed, TikTok has been the most frequently downloaded app since 2018, in part because of the accessibility of the short-form content. The COVID-19 pandemic, which normalized video conferencing and online interaction, has accelerated these trends. Third, certain social media and political changes have influenced marketing trends, including the current authenticity fad. What the fuck? Authenticity is a fad? I mean, authenticity feels like it goes back kind of far in philosophy, but okay. Apparently it's just a fad now. It's just a fad. It's just a fad now. That's fun. Who knew? Who knew? Video is an effective medium in conveying and construing an authentic identity because it can create a sense of transparency, intimacy, and trust. By the mid-2000s, a small but growing number of lawyers were starting to use video as a way to grab and hold on to a potential client's intention. Video marketing was endorsed by legal marketing professionals as a perfect icebreaker, adding a face-to-face element that could help introduce trust, and also a way for a smaller firm to compete on an even playing field than larger firms. Today, the same principles are being applied on a much wider scale with lawfluencers. An American legal digital marketing agency, Good to Be Social, notes, should I look up Good to Be Social? Maybe they're the marketing agency for me. Legal video marketing is more relevant than it's ever been. Nearly 90% of marketing professionals use video as a marketing tool. Video marketing dominates because it gets results. Individuals are likely to select a law practice based on the quality and messaging of the digital video presence. Wow, amazing thoughts. That's deep. Meanwhile, much of how any influencing is playing out hinges on mechanics and business models of the platforms themselves. Video platforms in particular allows creators to respond to their audience, interact with them real time. For example, answering questions or fielding suggestions on what they produce next. Do you guys have any questions or suggestions on what I should field next? This so-called co-creation of value is then reinforced through interactivity among consumers or audience members themselves. Increasingly then, both the meaning of value and the process of value creation are rapidly shifting away from product and firm-centered views to personalized consumer experiences. Moreover, social media platforms have subscribe, comment, and share features like comment, subscribe, which can generate strong in-group community membership efforts. The dynamics of homeopathy, in which perceived similarity leads to attraction, can amplify any sense of authenticity felt by the audience when engaging with an influencer's content wherever it lies on the professional amateur continuum. This is a lot of words for the prospect that people like things that they like. Yeah, the cognitive dissonance in this article is definitely, yeah. Yeah, they're taking shots at you, the audience, baby. They're taking shots at you, the audience. They don't like you guys either. They don't like you guys either. They don't like that, I might listen to you. They don't like, apparently, that I might ask you. They don't like, apparently, that I might interact with you. They don't like, apparently, that I might answer your questions. They don't like, apparently, that I might take your suggestions on what comment to cover. Apparently, they don't like you guys very much. But I guess it's because I'm allowing you, the proletariat, to commune with me, a member of the bourgeoisie. Or is that the other way around? Which is which? Either way. Yeah, I'm allowing you to communicate and interact with the echelon. And yeah. Moreover, in pursuit of financial rewards and or cultural capital, content creators are incentivized by the platforms to support the platform's business goals to produce content most likely to engage and keep viewers glued on the platform. Once again, yes, ideally, all things considered, I would like you guys to watch more of my content, interact with it more, watch more hours, provide more super chats. Yes, all those things would be good. I would appreciate all those things. That'd be great. This applies to the topic overall. For example, there are areas which most content is being created on YouTube: gaming, makeup, and beauty and reviews, unboxing, ASMR, and vlogging. We could always do law ASMR. As such, where an algorithm signals that particular type is trending, online content producers will notice this platform on a shift, likely through their analytics and adoption content to match. To further maximize engagement, content creators, including law enforcers, also commonly digital marketing strategies such as clickbait titles, sensationalist names for their videos, catching promotional images, thumbnails, engaging, exaggerated captions, and or metadata such as hashtags. As a financial driver, knowledge influencing in particular is an outcome of neoliberal movement. Wow. Neoliberal movement. Wow. Can I scratch my fingernails on the microphone? Hold on. As a final driver, knowledge influencing in particular is an outcome of the neoliberal movement, as scholars in the field have noticed, in which lines have been blurred between work and play, as well as between expertise and entertainment. Several studies have showed how the logic of entrepreneurialism and aggressive profit-seeking had affected professionalism, and to some, well, I mean, that is a weird comment to write. How Aggressive profit seeking has effective professionalism. You know one of the things that defines professionals typically? You know one of the things that defines professionals typically? They like to get paid. Bep, better. Baby, I got your money, don't you worry. Said, baby, I got your money. All right. So yes, there might be some profit seeking. And to some extent, influencing is a simple way for lawyers to achieve additional revenue streams, including against rising costs of living and other financial pressures. Where, however, these marketing tactics are taken to the extreme, such in the case of Giuliani hawking sponsored products and directing viewers to use his eponymous promotion code, the potential and to undermine the credibility of the profession is high. We now turn to these concerns. Holy shit, guys. These guys sound like so uptight. How tight are the assholes in Australia? These guys' assholes are tighter than a frog's butt, man. Damn. Shit. In this part, we contemplate some of the meaning of influences via video-based social media platforms for lawyer professionals. We look at 3 overlapping dimensions of professionalism that shape the trust and legitimacy of the profession and legal system in this context, access to justice and other professional public interest values, the client relationship and fiduciary relationship, and the identity, status, and welfare of lawyers, the profession, and the legal system. Exciting. Exciting. By the way, just to prove their point, I would like to take just a kind moment, if I can, to please just remind the 600 of you that I'm here that, I do appreciate all of you who hit that subscribe button. And by the way, as noted here in our lower corner, we now do have the Ko-fi link, or Ko-fi, depending on how you want to pronounce this word. You can now support us through Ko-fi or Ko-fi.com. Ko-fi.com/uncivil law. The advantage to me is I get a bigger cut. So it doesn't cost you anymore. Like $100 is still $100. But instead of me getting $70, I get $97. So that's a better deal for me. So, and also I suppose also implicitly a better deal for you too, because, theoretically you're giving the money to help support me. So, you can do that, and you can sign up for a monthly membership and all kinds of stuff. So you can support me at Ko-fi.com/uncivil law, and it will be appreciated. Thank you very much. And also, please remember to subscribe just in general and otherwise. And I hope you're enjoying my content. I do good. How is Rudy's behavior any business of the Aussies? I don't know. The Aussies want to stick their business up in it. What can you do? Ask Aussie Overlord about this. That'd be good. Yeah, definitely. I'd definitely like to see Aussie Overlord respond to this bullshit. Maybe he could go down there in person and slap them in the face. That might be fun. Or what is like an Australian duel? How does that work? Instead of throwing down the gauntlet and pistols and dawn, what's the Australian equivalent? Do you throw down the didgeridoo and it's boomerangs at dawn? How does it work? I don't know. I want to make sure when I challenge these guys to a fight, I do it in the proper Australian way. Or do I just chug whatever 24 cans of beer happen to be closest to me at the time, and that's the onset of the fight? What is the proper Australian way? I'm open for tips. In some respects, lawyers' use of video on social media platforms represents a new expression of the rule of law values and public service duty to which access to justice. Since the 1990s, the public interest commitment contains a consumer twist in which law or provision of legal services must also be transparent and oriented toward the welfare of the public as consumers. Law fluencing, and they're still trying to make fetch happen over here. Quigley down under, Quigley down under, sharp carbines at 1,000 yards. I don't think it was 1,000 yards in Quigley. It was something like, 1,000 yards would be a lot. I think it was like something like 700 feet in Quigley down under. The legendary sharp. You know your weapon, sir. An experimental weapon with experimental ammo. You could say that. Then let's experiment. Whitey, go right out with that bucket until I signal you to stop. Yeah, okay, I got it. Oh, incidentally, by the way, I also know that was actually done for real. Tom Selleck actually did that shot because Tom Selleck is actually a good shot. So that was actually done for real. I think a larger bucket was used than for the purposes of filming, so it would be bigger. But Tom Selleck actually did that shot for real. So I'm just saying that's impressive. So hey. In practice, most citizens, and Alan Rickman, of course, as always, steals the show as the bad guy. Alan Rickman, of course, is the best. In practice, most citizens have neither the inclination nor opportunity to physically attend hearings. And most of their understanding of how law operates is filtered through traditional media, which is one of the reasons that the Lawtubes are here to demystify it. You know what the nice thing is? That instead of, I continue to say, and I will stand by this until I die. It's like if Johnny Depp versus Amber Heard was not filmed, if all you had was mainstream media reporting on it, man, oh man, would that be a different story? Because they would have been able to color it in the way that the mainstream media did. But they even tried to color it, even with like all the commentary. So they even tried, but they couldn't get away with it because everyone could see it for themselves. So they tried, man. They tried. But the nice thing is, with so many lawyers commenting on so many different places, it's like, yeah. Was it 748 yards instead of 748 feet? Either way. It was still a good shot. In practice, most citizens have neither inclination nor opportunity to physically attend hearings, and most of their understanding of how law operates is filtered through traditional media. In recent years, as this Depp v. Heard trial exemplifies, a trend has emerged in which members of the public see the law via live-streamed hearings online. Not surprisingly, celebrity cases are the most watched, although Alec Baldwin wasn't, which surprised me. For example, the 6-week broadcast of Depp v. Heard on YouTube's Law and Crime channel comprised 83.9 million hours of viewing time, with a peak of 3.5 million simultaneous viewers during announcement of the verdict. Really? They had 3.5 million viewers? That doesn't sound right. $3.5 million viewers live watching the stream at the same time? That doesn't sound right at all. Nonetheless, as Susskind have noted, while the internet is providing access to greater quantities of legal knowledge or content than ever before, in this case, full legal trials, most of this information is indiscernible to the non-specialist. Well, isn't it nice then that there are lawyers providing all this wonderful commentary to help, hopefully, people understand it a little better? Isn't that a nice thing? This observation might help explain some of the colossal view counts on Lawfluencer, explanatory, etc. content. The number of views on Lawfluencer content about Depp trial, for example, are even more staggering than the trial itself. To illustrate, a 56-second video from Arizona lawyers Mark and Alexis Breyer, husband and wife law team, nice, analyzed the risk of juror bias as a result of Heard drinking a pink liquid from her bottle in court. Attracted 6.4 million views. Meanwhile, Mandel's at Law by Mike explainer video, Trial Explained in 60 Seconds, has received over 10 million views. By educating the public, Lawfluencers is instilling masses of newly available legal information. They're redressing, then, the knowledge imbalance between the lawyer and layperson, often called information asymmetry, a central point of consumer movement. In the context of the profession having historically performed poor in ensuring public understanding of law and legal process, they could be seen as a welcome change. Well, that's what I tend to think. I tend to think it's good. I tend to think it's good. This is a subject I care a lot about. I like this subject. I think it's great. And I want to share my knowledge with you because I like talking about it. And it's great. And I want you to talk about it with me. It's fun. So that's what I thought, but, earlier they were talking about, the erudite and aristocrats and, the barriers to entry and all the rest of it. And now there's just people talking about it because they want to. That's good. Good morning, Sledge and Wedge. Thank you for $Pi. I appreciate it. Conversely, and to anticipate some of the later discourse about the implications of lawfluencing for the institution, what is being shared about the law's meaning and values is not within the full content control of the lawyers in any practical sense, let alone the wider profession. We've already illustrated how lawfluencers often let their viewers decide the direction of their content through functions of the app, primarily in the comments. Again, there is a wide universe of law to cover. There's so much of it to cover, and I'm obviously interested in covering the content that's going to be the most well received for every possible reason. You know, I'm interested in covering things that are interesting to the most people. That sounds like a good thing to me. So yes, I am trying to find the content that you guys will like the best. That is one of the things I do. Also was indicated an even graver influence on the content as a platform, or the process of so-called platformization, in which the influencer tries to play the algorithm to maximize views, engagement, and profits. Again, yes, we do try to make sure our content will be well received. That's true. Lawyers aren't just commenting on the law from a public service standpoint. They're responding for their thirst for celebrity cases. They're responding to our thirst for celebrity cases. Yes, we're trying to cover the content you guys want to see. Gwyneth Paltrow's recent ski incident, for example, was watched by over 30 million people. In other words, this is calibrated and celebrated access to justice. Well, we're trying to cover the stories that are going to be most widely received, which is true of the newspaper, it's true of the television station, it's true of the radio station, it's true of the damn crier crying in some Austrian village somewhere, trying to decide what to talk about based on what people will be interested in. Yeah, I know. At the same time, video marketing on social media might be closing gaps by giving members of the public a greater selection of lawyers from which to choose, including low-cost options. Once remote figures hidden in offices and courtrooms, lawfluencers may make lawyers easier to find or appear more approachable than before. In this way, lawfluencing seems to support the consumerist argument that we need to increase the range of options for and by which the means can access legal services. But again, these issues are not easy to pin down. A critical issue to justice issue is the client's informed choice about which lawyer and which cost. In the online context, on the hand, consumers might find more low-fee options while being concurrently under-equipped to assess those risks that might attach to low-cost work. Further, if they choose an influencer who's more likely to be found or may seem to be more trustworthy, consumers may be more likely to be overcharged or at least charged more than they would for another lawyer providing the same level of service. Well, I mean, that's kind of up to the consumer, right? The consumer makes the choice. The consumer makes the choice of who. I don't even know what they're arguing for or arguing against at this point. If the consumer chooses the law person, then, you know, they're going to, and if it's, yeah, I don't even know what they're arguing for. These are speculative points that require further study. Well, thank you for the open speculation. That's just great. But instead, based on how influencers are usually able to command a price premium for their brand, it is logical that lawyers too could charge higher fees than they could have before having a lawfluencer profile. So in other words, our efforts at advertising and self-promotion have been successful, and now we can command higher prices. Wow, that's neat. Thank you. We've been successful in encouraging people to pay more for our services because they think that we're good. Moreover, consumers may find it difficult to evaluate the quality and expertise of lawfluencers, while wily lawyers may take advantage of the deregulatory nature of the internet to fake or inflate their experience. This has already occurred in the medical field, as Maddox has pointed out. Stephen Ho, a former emergency room technician, became a micro-celebrity on TikTok from his humorous advice and videos and advice about ER care. However, investigative reviewers discovered Ho had only worked in ER for a very short period and no medical training, despite his videos implying he has substantial experience. Since his revelations, his bio now states, "Jokes, not advice, not a doctor, retired ER tech." But this disclaimer and clarification relied upon Ho's being audited by users themselves, which is not assured. In a platform context where professional reputation and branding are critical, there's a real risk of similar subterfuge by self-serving lawyers, especially given the importance for professional places on status. Numerous cases of lawyers attempting to craft perfect versions of themselves ultimately exist. Well, I mean, yes, but that's kind of just true normally. People And that's also very just true of social media in general. People tend to want to put out a perfect version of themselves, generally speaking. Yes. In Ray Salvina E. Sangri, the State Bar of California suspended a lawyer for engaging in deceptive advertising for shared photoshopping image of herself with political figures and celebrities to try to appear well-connected. Meanwhile, in Legal Services Commission versus Richmond, Australian law student Jacob Richmond was convicted for misrepresenting himself as a legal practitioner on social media, allegedly trying to impress friends and family. As Bloomberg and Eckert have pointed out, Richmond demonstrates that the court is likely to take social media representation seriously, owing to the breadth of reach of its members, of the public the user does not know and who could potentially be misled. Finally, despite being banned by regulators from both practicing law and providing financial services, former Australian barrister Dominique Grusba continued to record and share professional guru videos with disclaimer that offer general advice or for educational purposes only. Grusba markets herself in terms comparable with access to justice values, selling herself as Robin Hood figure, who makes her passion and focus to level the playing field for everyone when it comes to accessibility of law, not just the wealthy. Okay, so yeah, I mean, okay, I mean, yeah, anyone can talk about law. It is, especially in democracies, it is owned by the people writ large, so everyone can talk about it. That's true. Of course, the bigger question, how much longer do I have in this article? Oh, like 10 more pages? Oh, Jesus Christ. I should have seen how long this thing was before committing to this thing. Oh, man, maybe I'll do it in 2 parts. Lord have mercy, I want breakfast. Of course, the bigger question here is it also applies to unqualified or underqualified influencers in whether those who are regulated are necessarily inevitably better placed than others to provide competent and ethical legal services and offer better protection, or whether there's unjustified protectionism in play. For many, technology might be the only workable solution to access to the justice gap, though writers typically refer to things like chatbots and automated document assembly. It remains questionable whether justice through technology means legal services that can be fully delivered via VAT and chat on social media. Okay. In the practice of public engagement, lawyers may be breaching ethical or legal rules against solicitation. Are you about to give us legal advice? Is that what you're doing? You're about to give us legal advice? Is that what you're doing? Are you giving us legal advice? Did you give us a disclaimer? That may occur expressly within videos or comments requesting viewers to enlist them for legal services, or impliedly through embedded links to their website. For instance, Dominican lawyer Kathleen Marenzes at Attorney Marenzes lists on her TikTok biography a link to book her legal consultation and her paralegal training program, in addition to her website, other social media sites, an affiliate link to beauty products she uses, and even the outfits she wears. What the fuck? Who cares? There's also a risk of inadvertent lawyer-client relationships when marketing posts are construed by viewers as legal advice or to imply retainers. For example, New York lawyer Alex Peter at Low Overruled had to add a warning to his TikTok, not your lawyer, after many of his lawyers referred to him as our lawyer or their lawyer, even confessed crime in direct messaging. Lol. Such ethical risks are highlighted on these high interaction platforms. To illustrate how these direct communications occur, in one video by Miami lawyers, Cesar Chukwama, titled, "Can you get a DUI for sleeping in your car?" Chukwama provides general legal advice by telling viewers to turn their car off, leave the cars out of reach, and sit in the passenger seat. Chukwama then responds to cars including, "How easily would that get thrown out in court though?" Caesar, legally it wouldn't get thrown out because technically it's still a DUI, but in front of a jury, DUI. And in front of a jury, better stories. If I put my keys in a location outside the vehicle before sleeping, is that okay? Yes, provided you can't quickly get in and operate your vehicle, which sounds generally correct, right? The law on DUI in most jurisdictions is as long as you're in the cars and the keys are readily accessible, then it's considered DUI, even if the car is parked, even if the car is off. So as a typical practical rule, if the keys are inside the car, then, that might be a problem. But if the keys are not inside the car, then yeah, legally it might not be a DUI. Of course, now the keys are outside the car and they could be stolen by somebody, but yeah, that sounds legally correct. Yeah, that sounds legally correct. So yes, it is DUI if you're sleeping in your car and the car is parked and you're drunk and the car's off, but the keys are in the car. Then yeah, that might be DUI in many jurisdictions. So if the keys are not in the car, or they were like in a trunk that they weren't in the passenger compartment, then maybe that sounds like that could be a valid legal defense. And also, incidentally, they're not saying that's wrong. They're not saying it's wrong. They're just saying, here's something they said. Was it wrong or not? Another example is California influencer and firm partners, David Pochwama and David Pultmer. How can I hire you, bro? I'm facing DUI charges in Inland Empire. Praying minds get reduced or dismissed. Cops gave breathalyzer in 6 minutes instead of waiting for 15. David says if you can prove that, you could potentially get your breath results tossed out, which sounds potentially correct if that's the rule. Right? If the rule is that they have to wait 15 minutes and they didn't wait 15 minutes and they didn't wait that amount of time, then yeah, you might be able to get the breath results tossed out. That sounds correct. So if you can prove that, you could potentially get your breath results tossed out. Sounds like correct legal analysis. If they have to wait 15 minutes and they didn't wait 15 minutes and you can prove that, then yeah, then the results aren't reliable. So you might be able to get them tossed. Sounds correct to me. If that's the rule. On the other hand, this type of communication seems like direct and customized advice. It's not. And even if it is, it's just saying, here's what's possible. It's possible. It could happen. This could be true. It's like, yeah. So it's fine. Because of the ease and often shortened format of video content, today, advice is literally to be off the cuff. But they're still not saying it's wrong. They're still not saying that they're wrong. They're still not critiquing the substance of it. Is it correct or not? Is it the correct answer or not? If it's the correct answer, then what are you talking about? Like if I say like something that's the correct answer, then, then I'm just giving good legal education. And that's a good thing. Excuse me. As Hensick observes, albeit in the context of law professors' use of Twitter, social media's low barriers to communication encourage professionals to make statements they would never make in other contexts, including statements outside their expertise. Having said this, as Noregarth points out, sometimes professionalism means speed and efficiency. High quality doesn't have to mean bespoke. Nonetheless, this is a new context that's different than, say, new forms of managerialism and professional workplace settings where there are blends that have been seen and examined to date. On platforms, the nature of advice given and whether it strikes the appropriate balance between efficiency and customization is significantly influenced by algorithms. The TikTok algorithm, for example, favors creators who post frequently, particularly with the frequently used hashtags, at least once a day, with some marketers advising ideally 5 posts a day. Incidentally, I'm now trying 3 posts a day, although they're re-uploaded clips, so I'm not sure how effective it is, but yeah, now that I have like a flow again, I'm trying to upload 30 to 60 second clips to like TikTok and other social media platforms to try to, help get the word out. So hopefully that will work to some degree. Consequently, by design and platform incentive, law influencers offer quality over quantity. Advice is more likely to be rushed, poorly researched, or even inaccurate. In these new contexts for lawyers, and as a practical point, disclaimers are essential. They include ensuring viewers understand interactions are not intended to create an attorney-client relationship, disclosing if any subject matter is outside their expertise, and clearly stating none of this amounts to legal advice. Meanwhile, law influencers who are not qualified to practice can only provide legal information. However, the line between that and legal advice can easily be blurred by the medium. These guys are pompous. These guys are pompous and arrogant. Elitist. We really love you. In addition, such interaction between lawyers and members of the public raise questions about the lawyer's fiduciary duties, including duty of confidentiality, which can apply even absent a retainer, which is true, right? Prospective engagement is covered by privilege. That's true. So if you come to me in a confined, then the information is privileged, even if I don't retain you, or you don't retain me, or I don't retain you. That's true. That's in the rules of ethics. As well as clients' right to privacy and informed consent. For example, Pulshami and Pulmer are known for uploading post-trial victory videos with their client outside the courthouse in which they outline trial details, strategies, and sentences received. These videos serve as client testimonials in a new, possibly more authentic, benignly amateurish form of referral compared to a Stamus text or word of mouth. However, the videos attached to the client's faces to the crimes is permanent record, giving rise to privacy and confidentiality concerns. Well, presumably they have their client's consent. So, whatever. The immediate filming of these videos after trials also raise ethical questions around informed consent and power imbalance. That the moment outside the courthouse, clients may feel overwhelmed with relief, gratitude, and adrenaline, and or feel put on the spot, dulling their decision making. Finally, marking themselves out from earlier forms of social media as part of authenticity amateur trends, TikTok and Be Real. I've never heard of Be Real. What is Be Real? Is Be Real a TikTok competitor? I've never heard of it. Do I need to open a Be Real account? Have come to incentivize users to share workplace content as part of the authenticity narrative. Dangers of ethical breaches may have also arisen, for example, in the office, when periphery computer screens or documents and videos could have allowed users to zoom in on content and see confidential information. Okay, well, I think I'm going to end it here because I've got 5 more pages. Can I make it? Oh, Lord. This is a lot of reading. And my voice is getting quite dry. I'll try. One of the chief concerns about the decline or reworking of professionalism in the face of increased commercialization has been the threat to autonomy and well-being of practitioners. On the one hand, lawfluencing is a new income stream. I'm going to put hashtag lawfluencing in all my videos. Hold on. One moment, please. There we go. On the one hand, lawfluencing is a new income stream, both directly by monetizing the video itself and also by attracting content. There we can see lawfluencing as another way in which the law has been commodified and more profit-seeking. On the other hand, this sort of activity might represent a new way in which lawyers can express themselves and enjoy their work, heaven forbid, where these platforms allow for and access professional identities to be melded together. At the same time, these issues are blurred and their ethicality less straightforward. For example, digital marketers advise lawfluencers to look inside their personalities for what makes them unique, to sell a point of distinction in a crowded market. Yes, that's in economics, that's also called the unique value proposition. That's the unique value proposition is what you just explained. Why is what you provide better than literally what anyone else provides? What is the unique value proposition? That is economics. Yeah, good times. My skin is revolting today. My skin is just rebelling against me in every way. My skin and I are having a bad time together. I don't know if I can keep going because I'm tired of reading. So let's see if there's anything else I need to cover from this article. And then we get to the conclusion. I'm going to call it here. All right. I think we've covered enough of this stupid for now. So I'm just going to call it because I'm tired. So yeah, that was some stupid. Yeah. Well, some people apparently at the bar have some problems, and yeah, all the rest of it. So yeah. And I need to figure out what's going on with my skin because I'm having one hell of a skin problem today. I'm having just the worst skin. I'm having the worst skin problem today, apparently. So yeah. So I'm going to go ahead and sign off and take a break and I don't know, do something else. But yeah, I'll go from there. Hydrocortisone? Yeah, I'll figure it. I'm just going to rub my face. So I'll figure it out. I'll be fine. I'm going to sign off for now. Hope you had fun. Video posted later. Thanks for all your support and love. I'll talk to you guys later. Until later, my friends, I hope all is well. Cheers for now, my friends, and goodbye.